Hello everyone, I'm Nazarat Fatima and you're watching LiveLaw. Lawyer strikes or calls for protest are quite something we all have a different take on. Many a time protests were held by advocates with respect to many issues, but the main question remains, is it okay for the system to accept this as a norm, or should there be an alternative for lawyers to address their issues? With respect to the same, the Supreme Court was considering a contempt petition filed by NGO Common Cause related to advocate strikes. A bench of Justice Dinesh, Maheshwari and Justice Sanjay Kumar was hearing the matter. The Supreme Court questioned the Bar Council of India on whether any steps are taken to ensure that advocates do not go on strikes or avoid court. The apex court said that it was proposed by the Bar Council that the rules regarding strikes would be amended. It asked about the progress of this planning. The chairman of Bar Council, Senior Advocate Manan Kumar Mishra, said that the rules are being framed in consultation with all the other bar councils. He said, and I quote, "Last week we convened a meeting in consultation with all the state bar councils. This was one of the agendas. On the basis of the suggestions made by different district bar councils, we are framing the rules." Mr. Mishra meanwhile said that the major issue that was discussed was the absence of a proper forum for redressal of the advocates' grievances. Responding to this, the bench said that it is being taken care of as the high courts are expected to form committees for the purpose of addressing advocates' issues. It is important to mention that another bench of the Supreme Court had recently requested all the high courts to constitute grievance redressal committees comprising the Chief Justice and two other senior judges, one from the bar and another from services, so that strikes by lawyers can be avoided or such situations would be avoided which lead to protests. The bench mentioned the case of Harish Uppal, in which it was clearly said that lawyers cannot go for strikes or protests. The court said that although the rule is quite clear from what was held in this case, but strikes are still being called. It said in addition, and I quote, "The point here, mechanism in place is okay. In Harish Uppal case, the dictum of the Supreme Court is that you cannot go on strike. Despite that, things do happen. The point here for BCI is only this much. If there are still shortcomings or faults on part of particular individual or a body, how do you deal with them by way of your statutory rules? That is what we wanted to take up." Mr. Mishra assured the court that the rules will be finalized within a week and the decision is to dissolve such bar associations if they do go on strikes. The court at this said that if the bar is compelled to take such a coercive step, it will have to do it as it cannot be helped. It said, and I quote, "If somebody does a thing which is impermissible in law, then you are forced to do it." Meanwhile, Senior Advocate Prashant Bhushan, who was appearing for the petitioners, said that the bar only has to make a simple amendment that going on strike will be considered as professional misconduct. As such, the court recorded in the order, and I quote, "Learned Chairman Bar Council of India, Mr. Manan Kumar Mishra, and Mr. Ardhendumauli Kumar Prasad submit that further steps have been taken for amending the rules as submitted before the court on the last few occasions. And in that regard, meeting of the representatives of all the state bar councils took place during the last week. And pursuant to the decision taken therein, the Bar Council of India is actively considering the necessary amendment to the rules. The submissions are taken note of." The matter will be next heard on July 17. That's all for today. We hope you like our content. If you do, please like and share. Also subscribe to LiveLaw and don't forget to press the bell icon for notifications. Thank you for watching.